Okay, because he's on the agenda, okay. Back in committee on March 14th, in Senate Economic Development, Housing and General Affairs, we are switching gears to Proposition 3, the right to collectively bargain and form a union. We have Peter Teachout from Vermont Law and Graduate School on the agenda. There might have been some kind of mix-up about him being present, but clearly he spent time on this issue. He's given us a 9-page document that's on our website, and we're going to pull it up now to review it. I want to remind folks that a constitutional amendment does not need to make crossover. And I've talked a little bit to the pro tem about things that may delay this. So we'll take our testimony today and then decide how we want to proceed. I almost want someone to like read it aloud. We could take turns. We could take turns. Yeah. Like Passover.
When,
Yeah.
what's my water? When
Do you want to start, Senator? And we can really decide when to.
Just do that paragraphs, yeah.
Well,
Yeah.
also, it may just be and the conclusions at the end may be also.
Senator Cummings, why don't you read the introduction?
Okay, I was gonna say, I think we can start over, skip over the first paragraph, that's his curriculum vitae, and
Okay,
okay,
Although,
yeah, I think we,
Well, the last sentence about what the PR3 does.
why don't you just do the whole thing?
okay,
Is this 9 pages we're gonna read?
No,
yes,
we're gonna go from the introduction to the conclusion and scan through.
Why don't we just, we're not gonna say, why don't we just take time individually to read it, so we can read that, that's what's in
Because
it.
just because he's on the agenda, I do wanna like formally acknowledge his presence through this piece in the introduction and conclusion, because that will still inform our conversation about next steps. So I hear you, but I'd like to honor that he's on our agenda and we should
okay, I will start.
know what he said.
All right. My name is Peter Teachout. I'm a professor of law at Vermont Law School with a field of specialization in state and federal constitutional law. I've published articles on federal and state constitutional issues in law journals and as book chapters. In my role as a constitutional scholar, I am occasionally asked to testify before committees of the Vermont legislature on constitutional issues. I welcome the opportunity to testify this morning before the Senate Economic Development Committee on constitutional aspects of PR 13, which proposes amending the Vermont Constitution to add a new article, Article 23, protecting the collective bargaining rights of private and public sector employees. I need to make clear at the outset 2 things. First, I am not a labor law scholar. Although I am generally familiar with state and federal law governing labor management relations, I do not purport to be an expert in that field. My testimony, therefore, will focus primarily on constitutional aspects of the proposed amendment. Second, the memo below reflects the result of a first rough pass through the available materials on state constitutional amendments in other states similar in thrust to what is being proposed with PR3. It may be that there are issues I have missed or that require further research. If that is the case, I appreciate having those issues called to my attention and am willing to take a second look. Second, the time allotted for oral testimony is limited this morning. I submit the committee's consideration the following rough draft memo in which I set out the key points that I think should be made. I
I'm happy.
I think I am happy to
Yeah.
summarize those points in my oral testimony, or as a committee prefers, simply make myself available for questions.
So I do hope he's all right, because
Yeah, I
it sounds
think
like
we
we
knew
have
that we were.
Yeah, so we don't have the benefit of Magali here, so we don't know what the last communication was between them.
Can you pull it up a little bit, because I want to hear the sentence that.
Well,
Okay,
why don't we, is this the paragraph that
Where did
you were
read?
quoting
I'll
from?
read the conclusion.
Let's
Yeah,
go to
let's
the
go to the
conclusion now, because this looks like a lot of legal stuff that we can't ask about.
No, but
but
that's all.
I
You know, we're all gonna
I
read it.
definitely want to,
We're all gonna
Oh,
read it,
yeah, we all care about it.
yes.
and we'll all get ours. Well, okay, very close.
Tentative conclusion. Got it.
I can't do virtual tours of houses, such as.
Oh, how long is the tentative conclusion?
It's an occupational hazard.
It's just, it's 4 paragraphs. Okay,
So
so,
we can break those up, that's easy.
Senator Markson, would you like?
Tentative conclusions and recommendations. Based on my research so far, I would like to share 4 tentative conclusions and recommendations. 1, in general thrust, I support adoption of constitutional amendment along the lines proposed in PR 3 and think it appropriate to add the amendment to a new Article 23. It represents in some respects, it seems to me, an appropriate counterpart to the newly added Article 22, which protects reproductive rights. Both amendments reflect not so much concern that the current state legislature will adopt restrictive legislation, but rather serve to provide long-term constitutional protection from restrictive measures that may be adopted by future legislatures. Both serve to signal the constitutional importance the state attaches to protecting the rights of those who in other states have been subject to restrictive limitations. 2, since actual experience with amendments similar to that proposed by PR 3 has been so limited, it's difficult to predict with any accuracy the sorts of constitutional challenges to which the amendment might give rise. But if there were major constitutional objections to adoption of the amendment, they surely would have been raised by opponents in the course of adoption and consideration of similar amendments in other states, and so far, that has not been the case. You want to take over?
Good. Do you want me to?
Yeah,
I agree. The policy-based and economic-based objections to adoption of an amendment along the lines of PR 3 have been vigorously asserted in the consideration of similar amendments in other states. It seems to me that in some instances, the concerns expressed may be valid ones, but whether those concerns are sufficient to outweigh the benefits flowing from adoption is a matter for the state legislature and the people of the state. That so far has not proved the case in other states. Whether the language of the proposed amendment might be modified in some ways to alleviate the concerns is worth considering. In the above memo, I have attempted to identify at least the basic thrust of those concerns. So we'll have to see that later. Or finally, if the legislature is prepared to move forward with a collective bargaining amendment to the Vermont Constitution along the lines proposed by PR 3, I think the language of the amendment as currently proposed could benefit from careful editing. I may be missing something, but it seems to me that the language of the Illinois amendment and of that under consideration in Pennsylvania does pretty much the same work as PR 3 and does it more efficiently. I also think that the California approach is worth considering.
Okay,
So now we know what to look at.
Yes, we
Damien
have
is
Austin.
written.
Yeah, we don't have Damien in the room, so he'll, I'm sure, read this as well. So I did just communicate with the pro tem's office, and we have today and tomorrow to work on this, which, I think they'll be fine with a vote next week, just to, so people can read this thoroughly and gather their questions, we can figure out if each other's okay. But we will continue with testimony today. We have Matt Musgrave in the waiting room. I don't see Damien yet, so he's probably held up in another committee. Yeah, he's held up, so we can have that discussion about that last paragraph regarding the other states, and I'm sure David can address that too. Matt, thank you for joining us.
Well, thank you for having me, Madam Chair. A little bit of an echo.
Hold on, we'll do the vol, we can do volume.
Is your volume up, Matt?
Yes,
Okay, great. Thank you, Olivia.
Now.
everything good?
Yeah.
Okay. Well,
Both of
thank you,
these.
Madam Chair and Committee, for having me in today. I appreciate you making the opportunity for me to do this remotely. I happen to be sitting in Los Angeles County right now. We are out here for a large national convention that's taking place down in San Diego for the AGC of America, and we're honored to be receiving a national award for a overdose prevention program that we put together that saved a few people this year. So happy to be here today. My name is Matt Musgrave, for the record, with the Associated General Contractors of Vermont. We're a trade association that represents contractors who do road work, bridge work, build buildings, build homes, do a lot of our civil work, as well as some of the environmental work that's very important to our community. In Vermont, we've got about 16 to 20,000 people that work in the construction industry at any given point. And we're proud to say that we do offer jobs with livable wages and benefits that we're very proud of. The employees in the state of Vermont are a very valuable resource. In fact, it's one of the most finite resources that we have in terms of performing the operations of my members. So they take very good pride in taking care of those individuals, and we're supportive of their motto of skill, integrity, and responsibility. So I've been asked to come in today. I really appreciate the opportunity to be here. I think that, we've spoken in the past about AGC's position on the ability to form and organize a union, and we are a neutral organization on that. We have members who are organized, and we have members that are not organized. And what we as a policy generally do, and you'll see me in your committees from time to time, is we follow the National Labor Relations Standard because we are engaged in interstate commerce, as are most private businesses in the state of Vermont. So we understand what those rules are for organizing. And one of the policy items that we follow is that we believe in the NLRB, and we believe in the right for an employee to choose what they would like to be doing without being harassed or offended by their employer, and vice versa. On the other side, we also want to make sure that it's the employee's choice, that they're not forced to join a union. So it goes both ways. We ultimately believe that there needs to be a fair process for that person to work through to make that decision to join a union or not to join a union. And that's something that we're proud to continue. So we're going to say no on both sides. If an employer wants to make it harder, or organized groups want to make it harder for an employee to choose whether or not, we're going to be right in the middle on that. And I don't think this bill even addresses the rules to join a union. I don't believe that this changes the Vermont Labor Relations Act in any meaningful way. I've been in contact with our constitutional attorneys, who are in fact labor attorneys at the national organization, and they've assured me that this proposition will not change the rules under the National Labor Relations Act, which supersedes the Vermont Labor Relations Act. And we are absolutely supportive of a program that would prevent the state of Vermont from, in the future, changing rules and making it harder for someone to make that decision. That's absolutely a personal decision to the individual. So with that, after reading the proposition before us here today, looking at Mr. Teachout's comments on number 4 conclusion, without knowing what that language he's suggesting, I don't have any opinion on it. But if functionally that language would make the bill better for what I believe the intention is, I generally have no problem with the bill. We would remain neutral on this, and if not a little bit supportive, you support your unions in the state. So, any questions?
Questions?
That's very clear.
Yes, thank you. Senator Clarkson.
So of your members, Matt, I know you represent both unionized and non-unionized. What percent are unionized and what percent aren't?
Well, Vermont's private sector is very, very not organized. You see it a lot more when you're working with state entities or larger institutional entities like schools and educations. So, I mean, to be quite honest with you, there are very few organized units that actually exist in the state of Vermont, representing very few people in the private sector. And I think it's really a testament to the choice of the employees that exist in Vermont. I'm aware of organizing activities that take place that are out there, so they're certainly exposed to the opportunity should they choose. We do talk to our employers on a fairly regular basis about what they see, and our employers are not engaged in any type of union busting. I've heard some testimony in other bills. I think S102 had a captive audience meetings and such that involved. We just don't do that. I mean, right now, the employee is the valuable resource and they're making the decision for what they do. And right now, employers are falling all over themselves to offer them higher pay, offer them better working conditions, offer them the lifestyle that they're looking for. And quite in the way that I see things work, and I'm not from a union family background. I came from the private sector. I was a real estate agent most of my life. But what I can see and what I can tell is it's very much a cultural thing. Like when I look at like states like New Jersey, New Jersey is 100% organized. There's virtually no outfits that exist within the state of New Jersey. And I think you've heard some great testimony from some of the professional union members that have been through here about how it was like their father and their father before them that was in the union that, and when I talk to folks that are in the union, they're very proud of it. It's, well, there was no other choice. We're a union family. So it's a cultural thing, and Vermont hasn't really moved there, I think, and it may have to do with, I think, the nature of our state. They talk about 6 degrees of separation. Vermont, we're like 1 degree of separation, and you'd be funny. You have a company with 50 or 60 employees. How many of them are related to each other? So I don't know what the reason is. It doesn't have anything to do with the fact that they're not being presented with the option. And I know for sure in my industry, it's not because they're being bullied. So so it's a very low percentage. I'd say probably 5 to 10%.
Thanks.
Senator Brown.
Matt, there is a provision in the amendment itself, essentially that says that in the event that a organization is organized, that the members, the employees of that organization must become members of the union. And I know we have some situations now, particularly with public employees, where that's not the case, where state employees, for example, they have the option to pay into the organization, but not become members of the union. Now, Professor Teachout likely addressed that in the 9 pages of text, none of which we've read yet, aside from the preamble and the conclusions. But based on what you saw Professor Teachout say, and what your concerns are about your members, does that provision potentially have any impact on the unionized members of your group, or about other companies that may become unionized in the future? Does that raise any concerns to you?
So if indeed it did force the hand of an employee to make a decision about being in a union or being unemployed, I'd have a significant problem with it. But based on my research and my discussions with an attorney that's a subject matter expert in the National Labor Relations Act, I can tell you that his response to me on this bill was a 1-sentence response, and this is fine. It does not involve your business at all. So to your point where it relates to the public sector, I do believe there was a Supreme Court decision that impacted that. And I don't know that creating a constitutional amendment at the state level would supersede a federal decision. And that's really a question for an attorney.
Great, thanks so much, Matt. Appreciate that. It is more helpful context than just neutrality. We would invite you to stay on. I think we'll have a little bit of general discussion. And I don't think we're going to vote this out today, but I know Damien should walk in the door in a minute. I'd love to get David in the witness chair. And yes.
Were we expecting a new draft? Because for some unknown
Yes.
reason, my notes indicate that we might be expecting a draft with some of the language.
You have it on your deck. It's not a new draft that has anything we haven't considered. It strikes the half sentence that was problematic about
Right.
fees. Yes,
Right to collect dues.
yes. So, with that gone, I think what,
Thank you. I
yes,
thought
Matt.
that's what we.
Madam Chair, I will hang around for a few minutes, but I do have to run at 11:30. I am in another committee.
Oh, yeah, okay, so feel free to leave whenever you like. We won't take.
I like visiting. It's just that I'm in 4 different committees this morning.
Well,
So
yes.
as David's getting in the witness chair, if people look at page 3 of Peter Teachout's memo, the language that he references from Illinois, I believe is now exact to our bill. We are striking the same partial sentence
Right.
that they discussed in Illinois and struck as well. So I think Peter Teachout was understandably looking at the introduced and not this draft 1.1. And so Pennsylvania and Illinois, we now have the exact same wording, and David will confirm that. And then Peter Teachout is here. Okay. Is that okay? David, you can stay there if you'd like.
Is this, so it's draft one?
Draft
Yeah.
1.1,
1.1.
proposal 3.
Okay.
So,
Yeah.
Peter, we anticipated your very thoughts. Peter, are you there?
Hello,
Hi.
Hello.
We can see your box, but not your face. Ah, now we see your forehead.
There we go.
Hi,
good
welcome
morning.
home.
Good morning. I just barely walked out of class, so I hope I'm going to be reasonably articulate.
Yes, you are fine.
Can you turn up the volume?
I don't know, you have the ability to turn up the volume on your side?
Yeah, Peter, can you turn your volume up? Cause we're up as high as we can go. We can hardly hear you.
I'm going to try to do that. I am not sure that I can, but let me see what I can do here.
Oh, that's okay.
Yeah.
That's better.
We should limit in how much we're on. If you want feedback.
Is that better?
Yes. Hello, Professor Teachout. Thank you for joining the Senate Economic Development Committee this morning and for your 9-page memo. That's extremely thorough and clear. We were looking through it before you got here in case that was our way of channeling you. So we're glad you could make it. And we have reviewed your introduction, conclusion, and I know I was personally starting to look through your assessment of the different states that had considered or passed a constitutional amendment. And I do want you to know that we have struck part of a sentence from our original proposal that now makes the language exactly what exists in Illinois and is being considered in Pennsylvania. So we appreciate, the nuance of what's being considered in each state. Is there anything that you wanted to say about the memo before we get into questions?
I don't really feel a need to elaborate on the memo. I knocked it together yesterday afternoon, and it's a little bit rough, but I think it makes the basic points I think need to be made. I'm sure I probably have missed some issues, but I think probably the best way to proceed is to proceed with your questions, and I will do the best I can in trying to answer them.
Great, I do agree. It does stand on its own. I think it's very thorough and helpful. And lays things out clearly. Even if it's 9 pages, we can handle it because it's very clear. The one difference now that would exist that you encouraged us to consider is, I believe, kind of the addition of a sentence in California that says the legislature shall provide for the enforcement of these rights. What's interesting to me is in our Constitution, let's say with reproductive rights or any other part of the Constitution, I don't think we feel the need to say that the legislature shall enforce it. Do you see something of value in that sentence that we should consider?
I agree completely with you, Madam Chair. Uh, I, I don't think it's necessary. I think whenever the Vermont legislature is considering either legislation or a proposed constitutional amendment, often in the preamble, it says, based on this and that consideration, this or that previous constitutional amendment, we are considering this legislation. So I don't think it's necessary. I was just curious and interested that California somehow felt the need to add that to
Yeah.
as it was initially proposed.
Yeah, it is interesting to me because often the legislature doesn't provide for the enforcement of any rights. It's the administrative and judicial branch that do that regardless. It's just a curious sentence to me as a legislator.
Maybe it needs money.
Right.
So any other questions, or now that you've tidied up PR3, make it identical to the Illinois amendment and the Pennsylvania, the amendment that's under consideration in Pennsylvania, it seems to me that really makes for a much more efficient expression of the policy that you want to have reflected there. There are there are some concerns that have been raised in the deliberations over adopting an amendment like PR3 as amended in both Illinois and in Pennsylvania. And they primarily deal, I think, with the second sentence in proposed Article 23, which is the sentence that begins, "No law shall be passed that interferes with, negates, or diminishes the right of employees to organize or bargain collectively." That has been the source of substantial concern on the part of opponents of the proposed amendments, on grounds that somehow that could potentially interfere with the ability of the legislature to adopt all sorts of beneficial legislation. And I indicate in my testimony that at least one of those opponents has indicated, or one study indicates, that as many as 350 pieces of ordinary legislation might potentially be affected by that provision, because legislation would be challenged on grounds that it somehow has the effect of diminishing the right of unions to bargain collectively for an agreement that they want to have adopted. So, and I gave an example in my testimony, and I think it would be maybe productive for us to share it anyway. Suppose PR3 were to be adopted and Article 23 were to be added to the Vermont Constitution. Suppose after that, because that provision that I just referred to is proscriptive only, it only applies to the adoption of laws in the future. What if after adoption of Article 23, the governor should say, school budgets are out of control. I think we ought to move negotiations over collective bargaining agreements regarding the health care benefits that teachers receive from the local level to the state level. If I were representing a local teachers union, I would say that sentence would give me purchase for challenging that decision on grounds that it would diminish the rights of my teachers to enter into a collective bargaining agreement that would be most preferable to them. Now, I don't know if that would, in fact, be a successful challenge, but the argument that opponents of that particular provision have made is that whether or not the argument is successful, it's going to invite litigation along those lines. Just a normal kind of piece of legislation. If the legislature wanted to go along with the governor's proposal, you move negotiations from the local level to the state level, it's going to have an impact on the collective bargaining rights of a local teachers union. So that is just an example of the kind of concern that has been expressed when measures like this have been considered in Illinois and also in Pennsylvania.
Thank you. Professor Teachout, you note that Illinois' amendment is so new that there hasn't been this kind of litigation or voiding of laws, or, you know, it's been hard to tell. There are states that have had right to work, so-called right to work, provisions enshrined in their constitutions for a little bit longer. Have you explored the implications or impacts of amendments that kind of do the opposite of what we're trying to do here and diminish the power and role of unions in collective bargaining?
Well, right to work laws and right to work constitutional amendments do limit the ability of representatives of teachers to enter into collective bargaining agreements that they would like to have adopted. Why? Because they basically provide that if the collective bargaining agreement requires that in order to continue employment, you must be a member of the union and you must pay union dues, that violates a right to work law. So what this proposed amendment would do, it would prohibit states from adopting, in this case, would prohibit Vermont from adopting a right to work law. It basically says it's okay, it's constitutional for collective bargaining agreements to require, and this is a little bit controversial, it's okay for collective bargaining agreements to require that you have to be a member of the union as a condition of continued employment. It's right there in the amendment itself, the very last words. Okay, so I don't know what you want to do with that, but that is basically the proposed amendment would prohibit any future state legislature from adopting a right to work law along the lines we've discussed.
You other Senator Brown?
Well, going back to the provision regarding public employee unions and the decisions that essentially have allowed members of those unions before the union was certified for that particular employer to not be required to become a member of the union or to pay agency fees. I'm assuming that you see that not as a problem because whatever is in this amendment, if that language remains, would be overridden or.
That is correct, Senator. You're referring to the Janus case, which was decided in 2018, in which the court said, if you're talking about public sector employees, you cannot, as a matter of constitutional law, require them either to be members of a union as a condition of employment or to pay dues to continue employment or to pay substitute fees. You can't do that because that violates their constitutional right to free speech and right to association. So that case out there is a limit on what you can expect the proposed amendment to do.
Now, in the case of private employers, that ability of a currently employed employee before the union agreement is reached, that person does not have a choice. They have to become a member of the union.
That is, if you're talking about private sector employees,
Yes.
under both the National Labor Relations Act, which governs collective bargaining by private sector employees, and under the proposed amendment, it would be legal for a collective bargaining agreement to say to employees You cannot continue to be an employee here unless you join the union and unless you pay dues to the union. So a very different set of rules for public sector employees and private sector employees under this amendment and under the restrictions imposed by the Supreme Court in the Janus case.
Is it curious that public sector employees have more constitutional rights than private sector employees?
It is true that they would, and they do. Yes, they do under the Janus case. Because basically they cannot be subject to collective bargaining agreements that require them to become members of a union in order to continue employment, whereas private sector employees can be subject to collective bargaining agreements that so provide.
Did the Supreme Court deal with that at all, or was the Janus decision what was requested in by the parties, the Janus decision, so focus only on public sector employees that this issue coming before the Supreme Court regarding private sector employees was not raised, or hasn't been raised previously, and have they decided that those rights don't exist in the same way?
My understanding, Senator, is that that issue was not raised, and I think the basic thrust of your question, if I understand, why are public sector employees treated specially in a way differently from private sector employees? And the answer is that public sector employees work for the government, and the constitutional protections, free speech, freedom of association, only apply if state are depriving you of your constitutional rights. Private actors cannot deprive you of your constitutional rights. So I think that's the private sector employees can't claim they are protected by the First Amendment because their rights of free speech and association are not governed by the Constitution. I don't know if that makes any sense, but that's why I think you see that differential treatment. However, I think your question, Senator, is a good one. Why wouldn't some of the rationale that the court employs in the Janus case at some point be applied by the court to private sector employees as well? Because in some ways, they are really being compelled to support the union by becoming members or losing their job. So it's possible that the Supreme Court will move in that direction, but the underlying distinction is based on the fact that government can't deprive you of your constitutional rights, but private actors and companies, no problem if they do.
It's interesting, the example that you chose, looking at the education funding issue, given what we're looking at for education funding. And the notion of moving many of these decisions to the state level is something that is being discussed right now. If this bill were enacted, that would obviously limit the ability to do some parts of the education funding reorganization that some people are discussing. I'm assuming that if that were the case, that obviously would be, quote, prohibited, and if the state tried to do that, particularly as far as union representation, we would be engaging in some significant litigation.
Well, you have to be a little bit careful, but you may wonder where I got that hypothetical from yesterday's Valley News. So but it's interesting. There are a couple of aspects to your question. One is that if you're going to do it, you better do it before Article 23 becomes the law of the state, because this amendment only applies to legislation passed after the amendment has been adopted and becomes effective. No laws shall be passed, so it doesn't apply to laws that are already on the books. But also, I think I would make the point, it would provide a basis for challenging that decision by the legislature if it decided to move negotiations from the local level to the state level. But it wouldn't necessarily be interpreted by the court as somehow diminishing the right of employees to bargain collectively. That would be the argument, that it does, and I think there's some basis for that. I know from my own experience, you've got more leverage at the local level than you might have at the state level to negotiate collective bargaining agreements. But it would become a basis for challenge, and it might well be found to diminish the rights of local teachers' unions to collectively bargain, and if it did, then it would violate the terms of this proposed amendment.
Thank you.
So I just want to say, Professor Teachout, I know you know, we're putting this together with the best resources you could find in a short period of time. When I looked at this report from IllinoisPolicy.org, just looking at the link down at the bottom, looks like you're going to like a, policy research and think tank that might be associated with Illinois government itself. It is in fact a policy institute that has a pretty strong political leaning. It talks about their public pension system being immoral, that people should have the right to choose, in terms of a union and work. And this organization tends to lean a little bit from their list of beliefs toward right to work. And their first statement is they are the strongest voice for taxpayers in the state. Not to say that there's anything patently wrong with what they're saying, but I just want to point out that looking at a citation that says IllinoisPolicy.org, they got a great website hyperlink that looks like they're quite neutral when I just want people to know that if you look at their homepage, they're very much leaning in a particular direction. So what we do know is that in the year since Illinois has passed their amendment, we haven't seen 350 laws come under attack that have to do with protecting children in school and things like that. So I just wanted to point out that I did do some looking at that citation, and I'm concerned about its 501c3 kind of organization that has created it that isn't affiliated with government.
Madam
Thank
Chair,
you very much.
Yeah.
I just want to follow up on Senator Brock's
Yes,
comment or
yeah.
question, and then the answers. Professor Teachout, if you could just explain, I don't understand why a bargaining at a local level is necessarily better for the union than bargaining at a state level. It seems like the personalities of the local folks could be very different, and they're, it just depends on the personalities, but obviously there's something I'm not understanding.
Senator, I think that is an argument that might be made, and the reason for raising it, I just said this may well provide a basis for a constitutional challenge. I was on the Norwich School Board for 5 years. I was chair of the Dresden School Board for 5 years. And I have sat across the table from representatives of the teachers union, and generally we were a pretty collegial bunch. We wanted to make things work. I think it might be possible that you would meet more hard-nosed negotiators at the state level where you don't work with these people every day than you do at the local level. So I just was saying, I can see if I were an attorney for the local teachers union, I might well use that as a basis at least for saying, hey, look, this is diminishing our ability to negotiate a favorable collective bargaining agreement. And if I could, for a moment, just respond to Madam Chair's comments about the sources I cite. Look, I agree with you 100%, and I'm glad you call that attention to that in the memo. My job, as I saw it, was simply to say, hey, what kinds of concerns have been raised? And what kinds of arguments have been made? As I say in my memo, I read that document and I say, boy, they're drumming up a parade of horribles here. All the possible ways that this provision might be misused. I
See.
my,
When
my
you cited
reaction,
that,
my
I know
reaction
what-
was, my reaction was the same as yours, but that was my job as I saw it. Hey, look,
Okay.
this is what you can expect. This is what the opponents are going to
Ah,
say.
this is.
Yes, right. I didn't know what the parade of horribles was referring to because we are doing a quick read of this. So I appreciate the exchange because I thought, oh, let me look at this website about what laws could be in jeopardy. And then I started to get concerned about the website itself. Yeah.
I would just mention, though, your comment regarding school boards is something that I have heard a lot. In that, the representatives of the NEA, or of the educational associations, who come to negotiate are professionals in that they have negotiated many, many contracts. But the folks at the school board have only negotiated one and typically are at a significant disadvantage in terms of expertise. With you being on the school board, that was probably different.
Fair enough, Senator. And so it might well be that instead of having collegial people sitting around negotiating a collective agreement, you'd have two hard-nosed groups with a lot of experience in negotiating at the state level, in which case a court would say, you brought a challenge, you lose. It doesn't diminish the rights of teachers to negotiate a favorable collective bargaining agreement. Would there be a possible constitutional challenge on those grounds? Yes. Would it be resolved in favor of the local school board attorney? No. Excuse me, the local teachers union attorney.
And I would just say what's coming to mind for me, I think Senator Clarkson and I were both in the House when an amendment narrowly failed that would have taken the right of teachers to strike away statewide. And I don't know where Senator Clarkson was, but I helped make sure that died, and it was by 2 votes. So
Yeah.
it was very concerning, and I think something like this would protect us from having to have a fight that was that close in the emotional height of a strike that was occurring that I think in fact led to better outcomes for the teachers in that particular district or a few districts.
Madam Chair, you're absolutely right. This would take that threat off the table if this amendment were adopted, because teachers would have a right to organize, they'd have a right to participate in collective bargaining agreements, and they would have a right to strike if negotiations were not successful.
Any other questions for Professor Teachout? This has been extremely helpful, Professor Teachout. I'm so grateful you put this together, and gave us a greater context. And as you said, you don't have the specific national labor subject matter expertise. We might try to get someone who has that before we take the final vote. But I think this has really given us a good grounding in our Constitution and how it relates to other constitutions.
Yeah.
Thank you again for your help.
Yes,
Yeah,
thank
I
you.
appreciate it.
Peter, thanks for taking the time
Yeah.
to do this, because we really appreciate it.
Yes, absolutely.
Yes.
Well, thank you very much. I've always felt that the Vermont legislature epitomizes democracy in action in a way that you cannot find in any other place in the world. And I appreciate very much the opportunity to testify, the opportunity to be quizzed and criticized. It's just to me, it is always just an important experience and trying to make democracy work. So thank you very much for this opportunity.
Well, thank you for helping us make it work better.
Exactly. And keeping us who we are.
Looking at its finest.
Yeah,
Thank you.
bye-bye.
Here. We have 15-ish more minutes. Damien, you had we have a new draft 1.1 that we started to look at. You had a clarification on the last sentence or the last phrasing that you wanted to make, and I know David can follow up on that as well. Because that again became the subject of discussion with Professor Teachout, and I think I want to clarify once and for all that you don't have to be a member of a union that collectively bargains with their employer in order to be protected under this amendment. So if you want to get on the next year.
Sure.
Yeah, that's a union shop where you have to belong to a union.
Right, right.
They have those and you have to pay them.
Yeah.
Okay. Good morning. Record, I'm Damian Leonard from the Office of Legislative Counsel. And I do need to be clear that I did not hear any of Professor Teachout's
Okay,
testimony except
yeah.
for the last 2 minutes.
We're also not taking the vote today, so you might want to read his 9-page memo. I think
I was
it's
just starting to
helpful.
look at
Yeah.
it, so.
So we will,
Um, So, when we spoke last time, there was a question about, the, excuse me, I'm just getting myself to the right federal statute. I've been bouncing around all morning.
Take a look from
Take a
getting
breath.
here.
yeah.
Okay,
seriously.
one day and 34 hours maybe now.
Right,
Oh,
yes.
except I've got the capital bill, so I've got a whole other week of this.
Well, and a constitutional amendment isn't subject to crossovers, so we might be
Okay.
meeting you next week as
I
well.
did not realize that, so.
But the language isn't really lengthy or.
So, when we talked last time, there was a question about whether, whether the last sentence or the last clause in the final sentence, so the second sentence of this amendment, which states that no law shall be adopted that interferes with, negates, no law shall be adopted that prohibits the application or execution of an agreement between an employer and a labor organization representing the employer's employees that requires membership in the labor organization as a condition of employment. So this provision relates to what are commonly called right to work laws. There are a number of other names by which they're called depending on where you stand on those laws or on union rights, and I'm not going to go into that. The common term is right to work, so we'll work with that. These are expressly permitted under Section 14B of the National Labor Relations Act, which is 29 VSA 164. And it says that nothing in this subchapter shall be construed as authorizing shall be construed as authorizing the execution or application of agreements requiring membership in a labor organization as a condition of employment in any state in which the execution or application is prohibited by state law. So basically it's saying that while the NLRA, the National Labor Relations Act, preempts state law in every other aspect related to private sector collective bargaining, it is not preempting the right of states to adopt right to work laws, which basically can prohibit what's known as a union shop. Importantly, we discussed last time that the union shop rights are limited by the Supreme Court to what are called Beck rights. And basically, employees in a private sector workplace where the employer and the union have agreed to require membership in the union. The employees have the right to say, I don't want to be a full member in the union. I am only going to pay for my share of the cost of administering the contract and nothing else, understanding that the unions often engage in advocacy on public issues, etc., or may pay dues to the national organization that engages in advocacy on those issues. So this has been upheld by the Supreme Court. those Beck rights are basically where the Supreme Court has drawn the line for private sector unions. So states have the right to adopt or not adopt laws that prohibit these union shop or agency shop agreements, where basically you're paying what we call in the public sector an agency fee. You're paying the agent to handle grievances, to negotiate the contract, to do administrative activities. You are not paying them for their political activity. In the public sector, and we get into a difference in the public sector because with public sector employees, we have free speech rights and the government cannot limit our right to free speech, except to the extent that it interferes with our ability to do our job. So, for example, I have the right to go out and support and contribute to any candidate I want. I don't have the right to come into this room and call one of you out because I didn't like the way you voted on it, because that would interfere with my ability to do my job. It differs in every workplace. Our workplace is kind of unique because I work for all of you. So, there is a line on free speech. But in general, employees' free speech rights are protected. The way the Supreme Court has come down on that in the last few years, they've reversed prior holdings from the 70s, and they've said having an agency fee in the workplace amounts to a free speech violation because we're forcing people who disagree with unions on sort of a conceptual basis. They do not like unionism. They disagree with the idea of unionism. They disagree with the idea of collective bargaining for state employees. And it could be for any number of reasons, whether it's a union issue, whether it's a fiscal issue because they think it hurts the state's finances, or they disagree with the health plan that's been negotiated, or something like that. In any case, those are all matters of public interest because it's the public fisc and it's the public the way the government does its business. In that case, the Supreme Court has said you cannot require a public employee to pay any amount to the union. So agency fees are struck down for public employees. It's different in the private sector. We've talked about this a little bit with the captive audience meetings and so forth. Right now, your private sector employer has the right to say, to talk about politics, to talk about religion, to ask employees to support politicians, to bring them into the workplace, to speak against unionism, et cetera. And it's different there because it's not the government acting. There are academic arguments at this point that the Supreme Court should also reverse the Beck holding. But at this point, that's all it is. So right now, the language, this is a long way of me getting back to saying the language in the amendment would prohibit us from adopting a right to work law. Nothing in that conflicts with the National Labor Relations Act, which simply says this act doesn't overrule a state law that prohibits union shops. The caveat is that if at some point in the future the Supreme Court changes its holding, that provision of the law would no longer be enforceable, or potentially would be unenforceable, and you might need to change it, or that provision of the constitutional amendment.
Kind of similar to reproductive rights, we still can't supersede the US Constitution.
Yep.
And so it's an open question, but we can do our best to fortify ourselves.
Right, and it's I think this language can be seen similarly to our public sector agency fee laws, which are all still on the books, but none of them are effective. The question for you is a policy question of, do you want to keep this language in here, knowing that at some point in the future, it could potentially be struck down, or it could stay on the books? And it's speculative of me to say one way or the other. Right now, I don't see a conflict with the NLRA.
Mm-hmm.
I'm not a constitutional scholar like Professor Teachout, so I'm not sure what guidance he provided you with.
Mhm.
I looked at the NLRA and I don't see a conflict. I I think at this point, there's discussion about whether the current Supreme Court here, which has expressed its appetite to limit some of the earlier Supreme Court's collective bargaining rulings, will approach that issue. But at this point, it's not in front of them.
Speaking of Professor Teachout, I believe we clarified with him something I want to confirm with you. He, I believe, was looking at the as introduced version of this that included the agency fee partial sentence.
Yeah.
And when we told him that 1.1 had struck that, we sought to confirm that this language is now exactly what Illinois has enacted. And that is what Pennsylvania is considering. You don't have to confirm that right now, but that's my understanding, and
Hold on up. Looking side by side.
that'd be nice.
So I'm working off of his quotation. They're not verbatim. So they're not verbatim, but I would say in all of their essential elements, they're basically identical.
Okay.
The differences are somewhat stylistic. So for example, they say employees shall have a fundamental right to organize and bargain collectively and through a representative of their own choosing. And we say that employees have a right to organize or join a labor organization for the purpose of collectively bargaining with their employer through an exclusive representative of their own choosing,
So you don't see a material difference where a word or a comma kind of completely changes the. And we don't have to answer that question today, I just want to,
I don't see a material difference.
We can continue to,
Massage it.
Yeah,
As long as there's no material difference.
Yeah, did he have a specific concern?
no, when I mentioned that we had taken that phrase out, he said, oh, then I kind of imagine you're right, but he
That-
was on
That
the
phrase
line.
was a material difference.
Right, exactly,
I don't see any others
yeah.
between them.
Maybe at some point, and it's kind of a curiosity for me, as long as we have legal experts tell us there's no difference, I'd like to look at ours, Illinois and Pennsylvania, just to see what tiny word differences might exist to make sure that makes no difference.
I could put together a side by side
Okay,
of the four for you.
what's the fourth one?
Yeah, what's the fourth?
I see you mentioned California.
And you can weigh in on that too, we talked about California's.
It's about enforcement.
It looks like more of an act than an amendment, and it says something about the legislature shall enforce this, which he agreed with us was kind of a weird thing, and we wouldn't want to do that.
Or also not.
Yeah, so I can look at
Yeah, that's
California
like-
and Pennsylvania,
Okay.
or I'm sorry, Illinois and Pennsylvania.
Yeah, we
and
should,
put those
because
together.
this memo is out there, we should make sure we feel really confident about the differences in each of the four.
Probably in there to require the legislature to come up with the money to force.
That could be,
That's
yeah.
what we do.
California's an incredibly complex and bureaucratic state, and so I don't know that we want to copy what they do anyway.
Or they may not have had confidence that it would
Right.
be enforced.
Yeah.
Right, but we want to be able to answer questions, for the next 2 years, really, that this is, we just have to make sure every word is meaningful, so we just want to check off.
Sure, I can prepare that side by side. When are you expecting to take this back up?
We will
and
probably
you need
take
that
it,
Side by side.
Tuesday for the side by side.
Okay,
I don't know what your availability looks like tomorrow, but we don't need to haul you back in tomorrow. We'll probably look at it again tomorrow and see if there's other witnesses.
so
Which I wanna talk
I'm,
with you about.
whatever time you schedule me for, I'm at least double scheduled.
Even on Tuesday?
You know what, then
Um,
let's just say we're leaving you alone tomorrow.
But yeah,
Maybe
no,
follow.
it's. I am working on the capital bill and they are in markup, so. I think actually Olivia got me for my one open time tomorrow, so well done.
Good.
I
think with all the
I'll see you tomorrow morning.
Okay.
Looks like they aren't starting markups till
We,
10
and,
a.m.
and
tomorrow.
she and I will, anyone who wants to, will further discuss exactly what happens tomorrow. And we may let you go, knowing that,
Okay, but side by side for Tuesday,
yes,
that's perfect.
and yeah, being able to speak about those 4 differences, by Tuesday would be great.
Yeah,
Yeah.
I'll highlight differences and I will review Professor Teachout's memo.
Great,
So I can answer questions
okay.
on it.
Thank you.
I appreciate the extra time. I cannot tell you how valuable it is right now.
Yes, yes, we
Well, I had
do.
forgotten you'd taken on Becky's whole load.
So
Not
let's-
full load, just capital bill.
We
So-
do have like 1 minute-ish left. Committee. I will look at and think about other witnesses we might want to hear from that are national labor relations experts. Is there anybody else you want or need to hear from? To before we vote? Likely next Tuesday.
When did Illinois pass this? Oh, so very recent.
It hasn't been over a year, so if people were to jump on litigation to nullify 350 clause or whatever that
There were
was.
some laws in Florida that just happened that were, in opposition to the intent
Right.
of this. So
Yeah.
I can't suggest an
Exactly.
expert
Yeah.
on those laws.
We will look for an expert. We will see you on Tuesday. I will
Yeah.
try to take you off. I'm so glad Olivia did that, but I will try to take you off because I think we'll aim to vote next Tuesday.
Yeah, I just think
Okay, I think you have me on 246 tomorrow, which is basic needs budget.
If we are voting that out tomorrow, so hopefully
So
it'll
I'll
be quick,
come in.
yeah, but
Yeah.
we'll see you.
I was gonna say that's I thought our time for basic needs.
Yeah,
Yeah, the
okay, yeah. So you don't have any other witnesses that you,
Not unless there are ones who can speak to the Florida law.
okay,
I don't have anyone.
national experts who know right to work in our state is Florida.
Yeah, the thing to keep in mind with there are really 2 schools of states out there.
Mhm,
There are right to work states, which fall into a variety of stripes.
yeah,
And then there are 3 groups of states. There's right to work states. There are states that, like Illinois, are enacting additional protections and I think Vermont probably falls into that camp based on recent years' legislation.
Mhm.
Yeah,
As long as the
and
House
there-
also passes it.
And then there are, I'm just looking at like past
Yes,
years
yes,
generally.
Yeah,
And then there are states where there's not a lot of action, but I think those are the minority now.
mhm, yeah,
And so that's really what you're seeing nationwide. So the conversation is really right to work states are going in one direction. The states that tend to favor collective bargaining are going in a different direction.
mhm,
Um,
okay.
Yeah.
Well, thanks, so, maybe this is on our agenda tomorrow, maybe just Tuesday, but to be determined. We have 45 new minutes from the cashless conversation, and we'll be aiming to vote out tomorrow the basic needs budget bill and the veggie bill. So if anybody has concerns or people they want to hear from before we vote on those, people saw a report that the auditor sent us and his concerns. I don't feel the need to have him testify tomorrow because we have had him testify on these concerns in this report before. He's welcome to ask to testify. He didn't in that email. So otherwise, the agenda will look roughly the same and we'll vote out veggie.
Are you looking for
We're not,
an amendment? to
no,
this being-
we're gonna let it go.
Just let it go.
Talk to GovOps.
I think we're gonna talk to them about
Yeah.
this.
Okay,
But thank you, I don't want you to do work that,
no, that's fine. I just wanted to make sure that I didn't show up empty handed.
Yes, we
for
appreciate
something where you
that.
were expecting.
Well, and I'm glad you made sure we didn't make you do work that you weren't gonna.
I think we're sticking to the technical corrections.
Yeah.
Great,
And updates.
good,
Thank you, Dave.
okay,
Yeah, because there are a lot of big conversations that this inspired, this
Yeah.
bill.
So as of right now, we'll just see you tomorrow on basic budget.
perfect.
You do not need to have anything ready on this.
Sounds good.
Thank
I
you.
appreciate it.
Yeah, thank
Thank
you.
you.
Good luck with the rest of today.
Okay.